Started. I'm going through these names and I see that we've got a lot of our clients on here. We've got a lot of, looks like Rachel's clients as well. For those of you that don't know Rachel, she is a CPA that works with a handful of our clients, and she wanted to offer this to her clients as well because estate planning is something that's necessary for everybody. And we'll go through why here in just a second. I also see that we have a number of guests that were invited by our clients or Rachel's. So thank you guys all for coming. Again, my name is Jaimin. I am the founder of Assurance Wealth Management. And today we're going to go through estate planning with attorney Don Henderson, who is the founder of the Henderson Law Group. And the purpose of today is to go through some of the main questions that we get asked all the time, try to address some of these for you guys, give you as much information as we can. And then towards the end, we will be answering any questions that you have. A little housekeeping up front here is at the bottom of your screen, there's a Q&A button. Feel free to press that and ask any questions at any point in time. It will be anonymous. Nobody will see it. Nobody will see your question or who asked, except for myself, Don, and Rebecca, who's behind the scenes here handling all the tech side of stuff for us. We will try to answer as many of these questions as possible throughout the presentation or try to address them at the end. Keep in mind, this is all for educational purposes. Please do not take any of this and go run with it after this webinar is done. All right. Please consult with either your financial professional or your attorney before you go and take and run with any of these ideas. This is all for educational purposes only, which also means any of your questions that you ask, if they are very specific questions to your situation, or if they are specific to your state, we may need to address those offline. Just a heads up to everybody. So first, Don, thank you for coming, man.
Thank you for having me.
Yep. So I think you and I both get a lot of the same questions from people when they first sit down with you. And I think the most basic general of questions that I get all the time is, does everybody need estate planning? I mean, a lot of people think it's just for the ultra wealthy that need estate plans and trusts and stuff like that. So I guess sitting from your side of the table is who does need estate planning, or what do they need?
When I think of the word estate planning in my mind, it's the understanding of how the law applies to the assets that you have. It's not necessarily a specific plan that you have in place. Those things do exist. We do specific estate planning plans as we see fit. But I think at a basic level, everybody needs to understand how the law applies to the specific assets that they own and how those assets are disposed of at their death.
Okay. So on a very basic level, is there something that everybody needs? I mean, people hear about wills and powers of attorney and trusts and all the common things that are on TV and everywhere else. What is it that pretty much everybody needs, or is there something that everybody needs?
For all the Texans, I think you at the very minimum need a will.
Okay.
There's some other documents that I call my core estate planning documents, such as a financial power of attorney, medical power of attorney, a directive to physicians, and a HIPAA authorization form. Those are kind of my core 5 estate planning forms that I try to have everybody do if they don't have any documents in place. But at a minimum, for all the Texans, we at least need to have a will in place, if nothing else.
Okay. And is that only apply to Texans, or, outside of Texas? I know you can't give the legal advice on what they need or don't need, but in a general sense, outside of Texas, why would they or would not need a will?
Yeah, the main thing that a will provides is predictability. You get to say what happens. If you pass away without a will, we call that intestacy. And depending upon your particular family circumstances, how many marriages you've had, how many children are of the marriage, or how many children are previous relationships, there's going to be basic laws that each state has in place that says what happens to your asset, depending upon your specific fact situation. And what the law says happens may not be what you want to happen, or it may not be how your family expects things to progress when someone passes away unexpectedly.
Okay. And you mentioned that wills will help with the probate process. I mean, what is that? What is probate?
Yeah, probate is kind of it's a, again, similar to estate planning, it's a catch-all term that we use. Probate is essentially you're involving the court system to wind up your affairs. That's at a bare minimum, that's what probate means. Now there's several different techniques or procedures that you can do in a probate, but at the end of the day, probate is you're involving the court system and we're establishing who gets what and who has what rights for probate.
Okay, so if you don't have, say, a will set up, or you don't have a trust set up, you don't have anything set up, and so when you pass away, then the courts are now deciding who gets what.
Right. So each state, the legislature for each state has default rules. So if someone passes away without a will, depending upon your particular family circumstances, to give you an example, where it's a second marriage and you have children from a prior marriage, there are going to be default rules in place for that situation. And the law will say who has the rights to what assets.
Okay, so and I've heard you mention this before when you're working with some of our clients, but so does the type of asset or what asset does that matter when it comes to probate? Are there non-probatable assets?
Right. So in Texas, we're dealing with probate assets and non-probate assets, which is extremely important to distinguish one from the other. A probate asset is any asset that's going to be controlled by the terms of your will. A non-probate asset is anything that's typically governed contractually. The easiest example is a life insurance policy. Probably everybody understands how a life insurance policy works. You have a piece of paper that says when you pass away, this is the person that receives the funds, and you write that in and you provide it to the life insurance company. Since that life insurance contract has instructions in the contract terms, that's a non-probate asset. So similarly, if you have a checking or a savings account, you can have a payable on death designation for those accounts, and it will turn that particular asset from a probate into a non-probate asset. With the probate assets being everything controlled by the will that's going to go through the court system, and the non-probate assets, which are passing outside of the will, outside of the court system, directly to the people who you have named in those governing documents.
Okay, so something like a beneficiary on an IRA or a TOD, POD on a checking account, those things are going to pass outside of probate, so they will not go through the process.
Correct. So when you're thinking about how you want your assets to be distributed to your beneficiaries, it's important to keep in mind at a bare minimum what are going to be probate assets and what are going to be non-probate assets. If you make the false presumption that everything's going to be controlled by the terms of your will, what you want to happen with your assets may not be the case. You may accidentally have a joint account with a child later in life just for the ease of finances. And once you pass away, that joint account's going to go directly to that child and not pass under the terms of your will. So you need to keep in mind how your assets work and whether they're going to be controlled by the will or whether they're going to go outside the will, outside the court system, and directly to your beneficiaries.
Okay, that makes sense. So what about things like real estate? I mean, do those have different sets of rules? Because there's very common thing nowadays is everybody to have for some people to have real estate investments. So how does real estate get passed on, whether it's an investment or their primary residence? How does that get passed on?
It falls under the same rules.
Okay.
So if you have a will, you can say what happens with the real estate in the will. Um, if you don't, those default rules that exist are going to apply for your homestead and investment property, things of that nature. There's other tools that we have available. There's things called in Texas, we have a transfer on death deed in Texas, which essentially causes your real property that you have to pass outside the probate process directly to the named beneficiary on the transfer on death deed. If you've ever heard the term ladybird deed, it's essentially a very similar arrangement where that property is going to pass outside the probate system. Uh, you can have real estate in trust, you can have real estate in companies. Any asset that's in a trust is also going to be a non-probate asset and pass outside the terms of your will and outside the court system.
Okay. And I guess kind of along the lines of the real estate, this is a question that I've had come up before, is the difference between separate property and community property, and how does that work when we're discussing a will or the estate planning?
Okay, yeah. So in Texas, we're a community property state. So separate property is essentially anything that you receive as a gift, you inherit, or that you bring into the marriage. There's a presumption that assets and income acquired during the marriage is community property. And with the caveat that if separate property does produce income, that is the income that the separate property produces is community property. So when you get into the nitty gritty of things, you have probate and you have non-probate assets, but at the same time, you're kind of creating a four square box because now you're also thinking about separate property and community property. So depending upon your family circumstances and the types of assets that you could have a community property probate asset, you could have a separate property non-probate asset, and you have these different boxes that you have to think about.
Sure. Okay. Well, and let's kind of go back to we asked the question about if you don't have a will. It seems like the will, your kind of five documents that you listed earlier, or what you consider kind of the necessary things for everybody to have. What if you don't have a will? I mean, what's worst case scenario? What have you seen actual scenarios play out that somebody that doesn't have a will, I guess kind of the risk reward. Like, what's the
Yeah,
risk of not having it?
yeah. So the risk of not having it is not understanding what the default rules are and how things are going to get divided. I have a couple of these probate disputes going on right now where it's a subsequent marriage and there's children from a prior marriage. And in Texas, we have pretty strong surviving spouse rules with regard to the homestead. And there's a division on community property and separate property. So it's an issue because the surviving spouse suddenly has all these children from a prior marriage. They have a seat at the table now. So that's a common issue for all the men out there who essentially say, I don't need a will. I don't want to do a will. One of the piece of advice that I give to those particular types of mindsets are if you decide not to have a will, when you pass away, your family doesn't have to pay one lawyer, they have to pay two lawyers. They're going to have to pay the lawyer to help the family, but then the court is also going to appoint an independent lawyer to make sure everybody's telling the truth. And your family's going to have to pay for that cost of that second lawyer as well. So having a will is at least will defeat the need to pay the court appointed lawyer in probate.
I'll say no offense to you, Donnie, but I don't think anybody likes dealing with lawyers, let alone having to deal with two of them.
I
So,
don't like dealing with lawyers either.
well, and you mentioned earlier, previous marriages and kids. What have you seen as far as issues, or does it make things more complicated if you come from blended families? There's a lot more of those these days, and so how does that complicate things?
There's more things to consider. For example, if you don't want a complicated will and you just want everything to go to the surviving spouse, even though you have children from a prior marriage, you need to understand that that spouse has the ability to change their will in the future and to cut your biological children out if that's the decision you make. There's really not a good way around that scenario outside of utilizing trusts, which add a layer of complexity and cost to the estate planning process. Um, for minors, until they reach the age of 18, they're not legally capable of holding or managing property. So you can't leave real estate to a minor. Under very limited circumstances, there's bank accounts. There's a Uniform Transfer to Minors Act for bank account statute that a lot of the states have adopted. But by and large, you can't leave property to a minor. So you're going to have to establish either a trust in your will or a standalone trust to deal with that. And similar situated, if you're not a minor, you may have a legal disability or a physical or a mental impairment that you receive government or state level benefits on, and those types of people inheriting property, it could disqualify them from continuing to receive those benefits. So if that's a particular scenario, you need to think about having an estate plan that does not disqualify that person from those government benefits, but allows the person to continue to receive the government benefits, but also to utilize the assets that they're going to inherit in some way to enhance their life.
Okay. So in that kind of situation, you've got a beneficiary that is either a minor or, you know, can't manage the assets on their own.
Can't manage, yeah.
So, and you mentioned a couple of different types of trusts there as far as setting up trust for those types of beneficiaries. I mean, what are the common types of trusts, or what are the types of trusts that you see that are used most often to help in those situations?
Yeah, so let's go through a couple definitions. So we have revocable trusts, which
Hmm.
essentially means that the person making the trust has the full authority to change everything and to terminate the trust if they see fit. An irrevocable trust is a trust that cannot be terminated, and it may be rigid on modifications to it as well. It depending upon the type of trust, it may be set in stone. It's irrevocable. You can't change it. You can't get rid of it. So those are the two types of trusts. Um, Now you can create a trust during your life in a standalone document, which typically referred to as a living trust. You may have heard it, the phrase inter vivos. That's the same thing, inter vivos trust, living trust, or a testamentary trust. And a testamentary trust is just a trust that is established inside of your will. So those are kind of the overview of the buckets that trusts fit into. As far as for minors or for incapacitated persons, people typically utilize either first party or third party special needs trusts. Those are the types of trusts that help with Social Security, disability insurance, SSI, Medicaid, and things of that nature.
Okay. So when you're looking at these living trusts, and will they help with the probate process as well, or does that still kind of lean on the will? Like, what's the difference between the trust and the will, and how do they handle things?
Right. So at the end of the day, they're both just pieces of paper. Um, Once you establish a trust, you have to fund it with assets. So if you have a bank account in your individual name, you're going to have to retitle it into the name of your trust. That may require you shutting the bank. If it's a big bank like Chase, Bank of America, that may require you to shut your bank account down and reopen it in the name of the trust under a new account number. Not all the banks will just let you transfer your account number and retitle the name on the account. So everything you place into a trust is going to pass outside of the probate process and outside of the court system. So it's a one of the fairly basic strategies that people can use if that's an estate planning goal of theirs, is to avoid the court system, is they can fund a trust with various different kinds of assets, and they have the ability to name their beneficiaries in the trust just like a will. And if there's a reason that beneficiary can't be the trustee of the trust at a later date, you have the ability to appoint third parties to help manage those funds on behalf of the beneficiary. If you have a kid that's, if you give them $100,000 and it'll be gone in 24 hours, you can put it in a trust with a third party beneficiary with some type of distribution standard that says when that kid can get money for school or doctors or whatnot. And that third party trustee will be responsible for managing the money to make sure it lasts as long as possible.
Okay. So who would need a trust versus who does not need a trust? I mean, you've sat down with a number of my clients before and told some of them you don't need a trust. You have a lot of assets, you have a lot of things going on, but what
Mhm.
they wanted to do, you told them they didn't need a trust. They just needed kind of your five common documents. So what distinguishes between who needs a trust and who doesn't?
Yeah. It's basically more the more wrinkles you have in life, the more consideration you place towards that. So I already mentioned a blended family circumstance where if you want to guarantee that your biological children have a chance to inherit your assets after the surviving spouse passes away, you're going to have to leave your assets to the surviving spouse in trust. For people who can't manage money, I recently helped a grandma whose her concerns over her daughter would just the money would be here today, gone tomorrow because people would take advantage of her. So we formed a trust so that her daughter can be taken care of by a trustee, and so that she'll still want for nothing, but she won't have the burden of managing the money and to making sure that it's going to last for the rest of her life or that people will take advantage of her. Trust can also provide protection for third party creditors, depending upon how the trust is set up or what type of trust it is. If you leave assets in trust to a beneficiary and you have the right spendthrift language, third party creditors won't be able to attack that trust if the beneficiary gets into a car wreck and there's not enough car wreck insurance to take care of everybody. So there's some liability protection that trusts can offer beneficiaries as well.
Okay. And then one of the things that I always hear from people when discussing estate planning is, their asset level is that we have such a high, estate tax, for what is it, 13.6 million, something like that right now.
Right, yeah, per person.
Yeah, and so there's, I don't have $27 million, so why would me and my wife need to set up this estate plan or set up the trust or that kind of things? What do you typically say to people that are in that boat where they may have 2, 3, $4 million, they don't have 27?
Yeah. Yeah. So thankfully, we currently have a really high number. Um, that number as of January 1st, 2025 or six, I'd have to double check. It has the real possibility of halving. So for the people that have a few $1 million, we typically focus on payable on death designations and transfer on death deeds because more often than not, people, everybody has the same stuff. We have bank and financial accounts, retirement accounts. We have the house we live in. It's generally pretty straightforward stuff. And so we typically focus on payable on death designations for accounts and real estate and things of that nature so that without going through the complexities of forming a trust and funding the trust and making sure it's managed correctly, we're doing these. It's a lot of I's to dot and a lot of T's to cross, but it's a more straightforward estate plan in the sense that there's not the additional layer of complexity. You have the designation that says who inherits when you pass away and who that account goes to.
So would you say that for people in that situation now, it may be better not to get the trust, but just do the payable on death, just do the beneficiaries? And thinking about the fact that if they've got a few million, that maybe that'll grow, maybe that'll double, maybe that'll triple by the, 10, 15, 20 years from now. And then obviously by then we're going to probably have 15 legal changes, when it comes to the estate tax. And then maybe down the road when they're above that level, then that's when they should set up a trust, or should they set one up now, or is it kind
Yeah.
of a person by
Yeah.
person, situation
So
by
right now
situation?
we're in a weird situation. The current 13 million and change per person exemption, that it's planned to expire in a couple years. And when it expires, we expect that the new exemption amount is going to be somewhere between 6 and 8 million per person. So we don't know what Congress is going to do. It hasn't really been in the news cycle that this is coming up. And the last time this was an issue back in 2012-ish, Congress didn't do it in time. They did it a couple months after the fact. So similarly, we're in this approaching gray period. So for people who have the assets where they're coming up against the current figures, they have a decision to make whether or not they want to try to use some of their 13 million and change now, because if you use it now, there's and the number goes back down to 6 or 8 million, there's no penalty associated with that. So if you use it, you can use it now and not suffer the consequences if the number goes down in the future. So for those people in that kind of that asset range, they have some serious thought to consider on if they need to do some real estate planning and push some assets outside of that estate tax threshold.
Okay. But the people that are in the, we'll call it 500,000 to $5 million range, this isn't really a concern for them just yet, right?
Not yet. So not quite yet.
Okay.
So for example, if you're married, there's an unlimited amount of money that you can leave to your surviving spouse, estate tax free. And there's also something called portability, which is where, just say there's a married couple, husband leaves everything to the surviving spouse, and he files an estate tax return and it transfers his estate tax exemption amount over to the wife, so that when the wife passes away, she'll have whatever the estate tax exemption amount is when she passes away, but then she'll also have the figure from the year that her husband passes away. So she'll be able to use both of those figures combined to shield all her assets from the estate tax threshold.
Okay. Are there, when it comes to the estate planning process and setting up whether it be a will or a trust or any of that kind of stuff, is there any other sort of tax savings other than the estate tax? I mean, is there any other savings or reasons for, financial reasons for them to set this up?
Well, nobody wants to pay taxes. And some people are philosophically inclined against estate taxes. So that there's different tools that we can use to try to avoid paying those estate tax. I believe the highest percentage on the estate tax rate is 40% at the moment. So all the assets above whatever your exemption amount is can be taxed up to that particular percentage point. So at a most basic level, you need to think about whether or not that has the real possibility of applying in your future. And if the answer is yes, you need to start speaking with someone to see what you can do about saving your future beneficiaries' taxes.
And you mentioned the earlier on about the future, about your beneficiaries and the costs that they're going to have if you don't have everything set up and in place. I mean, obviously you can't give an exact number because every situation's a little different, but just in a general sense, when it comes to the amount that you're going to have to spend or that your beneficiaries are going to have to spend, excuse me, when you pass away on the two attorneys that you talked about versus what it costs to just set this up properly the first time. I mean, how big of a difference is that? I mean, because it's something that people are going to look at is why do I need to spend, a couple $1,000s right now to set this all up? I mean, I'm assuming when you're paying for two attorneys, it's going to cost way more than a couple $1,000s if you have to go through the process.
Right. Yeah. It's basically you're doing an opportunity cost analysis of paying some amount today to prevent somebody paying a lot in the future. To give you an example, in Texas, a straightforward independent probate for someone who had a will, that's at a bare minimum, that's probably going to cost you $3,000 to $4,000. And for someone who passes away without a will, the number's easily going to double, if not, it's going to be a $10,000 attorney fee cost. So and then when you get into the situation where you don't have planning, and then maybe there is an estate tax issue, now you're paying several $1,000s in estate taxes on top of your attorney's fees. So it could snowball quickly if you don't want to do some due diligence on the front end.
Gotcha. So spending the couple $1,000s up front could not only help people from spending 2 to 3 times more than that when they pass away, but also to ensure that all of their assets are going where they want them to go.
Yeah, it's the predictability of everything.
Gotcha. So I've got to ask. I know, yeah, I know you're a big fan, but I've got to ask. So why would somebody come to an attorney like you or, some other local estate planning attorney versus just going online and getting this done through one of those robo attorneys that you see online?
Yeah. So yeah, LegalZoom.
Yeah.
The quick and easy answer is that you don't know the information to put into LegalZoom to get what you need. So more often than not, unless you have a very simple family situation, uh, LegalZoom's probably not going to spit out the document that's best for you. Um, attorneys talk all the time about having another internet will came into their office and it's a mess and it's going to cost thousands upon thousands of dollars to fix in the probate system when they could have, paid a little bit more than what LegalZoom's offering and gotten a better will from a better attorney.
Yeah, so I've seen that firsthand with you. People coming in with those, and it seems like more often than not, it's easier to just create a new one blank than it is to
Yeah.
try to fix the one that they came in with from LegalZoom.
Yeah, it's usually easier to start from scratch.
Good deal. Good deal. Well, I mean, that's the questions that I had prepared for you. Those are the ones that I get the most often, and what I hear the most from our clients about estate planning and their typical questions around it. We've got another 30 minutes here that we allotted for this. So for the rest of this 30 minutes, I'm going to go through. We had 1, 2, 3, 4, 5, 6, 7, 8, 9 questions that were sent in prior to this. Plus, I'm going to advise everybody that's on here that has any questions about anything that we talked about. Go ahead, start typing those in the Q&A, and we'll just start going through everybody's questions to make sure that you get out of here with the answers that you were looking for when you joined in. But the first one I had here was, what about a living trust to avoid probate? I think you talked about that a little bit about how a living trust can help avoid the probate process.
Yeah,
You expand upon that a little bit?
yeah, it's one of your basic tools. A living trust is basically a standalone document, meaning it's separate from your will. It's essentially doing the same thing. It would work in conjunction with your will, but the benefit being that all the assets that you place into that living trust get to pass outside the probate process. So you don't have to involve the court system in those assets.
Okay. Had somebody here ask, can you rename those 5 documents that you recommend everybody having?
Yeah, it's a will. It's a financial power of attorney, which is sometimes referred to as a durable power of attorney, a medical power of attorney, a directive to physicians, which is a Texas specific document. It covers if you're diagnosed with some type of terminal condition and you're expected to pass away within 6 months, you can provide your instructions on how you want to be treated when you can't make decisions for yourself anymore. Uh, and the HIPAA authorization form, which is basically your medical information form that you can put people's names down who can ask medical questions about you without you being present. So that, yeah, will, financial power of attorney, medical power of attorney, directive physicians, and HIPAA form. Yeah.
Perfect. Thank you. Had the question about the living trust to avoid probate. Same person asked, is it better to do a transfer on death in conjunction with a will than to do a living trust?
It depends. Um, it depends upon what you're trying to do with the living trust. Sometimes, depending upon family circumstances, we might utilize a transfer on death deed to a living trust. A good example of why I would do that is just use your house for the house that you live in primarily. For example, in Texas, we have various property tax exemption amounts that we have the benefit of. And sometimes people working at the appraisal district don't understand that you can still get your exemptions if a trust has the magic language in it. So instead of having the burden of you reapplying for homestead and over 65 exemptions, sometimes we'll just do a transfer on death deed for your homestead to a trust. So that way you don't have to deal with bureaucracy during your lifetime.
Good deal. I had a question here about a spouse having dementia. What things do you need other than a will and power of attorneys?
Okay, so if your spouse has a dementia diagnosis from a doctor, I would encourage you to seek estate planning counsel sooner rather than later. In Texas, the law has you have to have a certain level of mental capacity in order to sign and execute a will and the various powers of attorney. So being able to do those, have those documents prepared and signed by the person with the dementia while they're able to maximize the portion of their mind that they have left is best. You don't want to be in a situation where the person is too far gone and it's really too late to execute the documents anymore, or if you do it anyway, then whether or not someone's going to fight over them in the future. So I would encourage the person to have a will, a financial, and a medical power of attorney at a minimum. You can have a trust conversation as well, whether or not a trust would be necessary for that situation. And what those documents is essentially doing is trying to keep you out of a guardianship situation. So uh, you, a guardianship situation is going to be costly. It's going to be time consuming, and the court's involved in your business, and nobody wants that.
So you're saying that the will and the powers of attorney will help avoid that
Will help
guardianship
avoid the
situation?
guardianship process in Texas. Yeah.
Do you think
Those
that
are
they
some
need
of the
any?
tools.
I'm sorry, go ahead.
Those are some of the tools that we use to try to avoid guardianship process.
Do you think that somebody like that would need anything above and beyond the will or powers of attorney?
We could talk about whether or not a trust would be a good fit as well.
Okay.
Um, so it depending upon type of assets that they have.
Situational.
Yeah, it depending upon the assets they have and what the exact circumstances are and how that person's doing medically, we can have a conversation about trusts and other documents.
All right. We have a question here about real estate property. What is the best way to structure that inside of a trust? And what are the differences between a revocable and irrevocable trust and the benefits of each?
So we touched upon revocability and irrevocability a little bit earlier.
Mhm.
Revocability is basically the person who set up the trust. They have the ability to modify it. They have the ability to terminate it. Irrevocable trust is the opposite. It's set in stone. It's only going to terminate under the provisions contained in the trust. Like a good example would be someone reaches 25 years old and the property is not held in trust anymore. But an irrevocable trust is going to be set in stone. The best way to structure real property in a trust, you have to first look at whether it's your primary property for your home or if it's an investment property. If it's an investment property, you can have the conversation about whether or not your trust wants to form an LLC so that LLC can own real property. But for people in Texas, it's important that if your homestead is in a trust, that trust needs to have the magic language so that you can still get your homestead and your other property tax exemptions.
Good deal. This kind of goes along the same lines. Rental properties, establishing an LLC, which I know isn't really the estate planning side of things. That's just more of, the liability side of things. But I guess you can speak on that as well. Do you believe that it's good to establish an LLC and put the rental properties in that?
Sure. I mean, the limited liability company, it's designed to stop any liability from accruing to your personal assets. So if there's a slip and fall at a commercial property and the limited liability company owns the property, it's designed to keep that slip and fall liability contained at the company level and not to slip into your personal finances. Um, there's a new tool called series LLCs that are out there. I don't believe series LLCs have been adopted by every state. So if you're using a series LLC to invest in multiple states, you need to be careful and you need to understand whether that potential state has either adopted series LLC statutes or if there's any type of case law in the books that shows that they're going to go and give full faith and credit to the state of formation of that series LLC.
All right. And then I got it. What is the relevance of current estate planning formed in another estate? I'm assuming they meant in another state.
Okay, yeah. So in Texas, if your will, say you have a New York will, so long as that New York will was executed under the formalities required by New York, it will be a valid will in the state of Texas. The issue will be that, does the New York will have enough of the magic language that Texas requires to have an easy probate proceeding? So some of the magic language in Texas is an independent administration without bonds. Other states, they may do their probate differently, and that type of language may not be in their wills. So if you're going to be a permanent resident of, if you expect to be a permanent resident of Texas, I would encourage you to redo your will with a Texas attorney, have a Texas will to make sure it has all the things and says all the things that it needs to say, so that if there ever was a probate, you're not going to have any issues.
All right. So that's basically from any state to any state. That's not necessarily just Texas. If you
Right.
move, you need to make sure that your estate is set up in the way that
Yeah.
that state requires. Okay.
Right. Yeah. You need the document needs to have the language that your current state of residence needs to have the best probate experience possible.
Sure. Cynthia, just letting you know that question is more of it's more along the lines of your investments than it is your estate planning. You and I can answer that offline. Just shoot me an email, or actually for everybody, at the end of this, when I close down the record or when I close down the webinar, it'll take you straight to a page where you can schedule a time to talk with either myself or Don or both of us. Just go ahead and schedule a time, Cynthia, and we can answer that question offline because that's more of an investment related question. Don, we have another one here that is, what is the difference between a living trust and a will? Does having a will prevent going through probate? Kind of already answered that part of it, but can you describe the differences between the living trust and a will?
Yeah, they're basically two separate documents that are accomplishing the same thing. The will doesn't prevent you going through probate. It's the opposite. The will is what's going to go through probate. So it's the will is going to control your probate assets, and the trust is going to control whatever those non-probate assets are that are in the trust.
Okay. Looking for information on tax implications and preparedness. As an 81-year-old with a trust in place, what else do you think I should do? I think that's kind of, Mary, that's a little bit of I think, a vague question. You can't answer necessarily what you should do specifically
Yeah,
without knowing a lot more of the details.
I would recommend that whoever set up the trust for you, you can go back in and do a kind of an asset review update to make sure, one, your trust is properly funded depending upon what type of trust it is, uh, and essentially do an estate plan review with that attorney. They can let you know if something's changed or if you're still okay with the documents that you have.
All right. Adam, you said you were mainly interested in reducing tax liability. We went through a little bit of that as far as the estate tax is concerned. We also had another question that maybe will fit into this. And I'm not sure if it was asked towards me or you, Don, but can you explain step up in basis a little bit and how
I
that
can,
works?
yes. So you won't say you own real estate and you purchase the real estate for $100,000. When you pass away, the real estate's worth $500,000. And the people that are going to inherit that real estate are your children. So once you pass away, under the hypothetical that I put forward, your children receive a step up in tax basis, which essentially means on the date you pass away, the tax basis that the children have in that real property is going to be the fair market value. So it would be $500,000 in this situation. So they're not going to be penalized by you having a low tax basis. You know, you'll get penalized if you sell that property during your life. You'll have taxes you'll have to pay on it. But if you hold it till death, your beneficiaries will receive a step up in their tax basis, so that if they inherit a $500,000 property and they sell it 30 days later for $525,000, then their liability is only the $25,000 and not the $425,000.
Okay, kind of a play off of that is when you're talking about these living trusts or these revocable trusts, non-revocable trusts, and somebody puts assets into one of these trusts, and let's say, they're stocks for simplicity purposes. That stock grows, they sell the stock, there's now capital gains on that stock. Does the trust pay those capital gains? Do you pay those capital gains? Does nobody pay those capital gains? How does that work?
Yeah, it's going to depend. It's going to depend on the type of trust. So if you have a revocable trust, a revocable living trust, it's legally speaking, it's it's not an entity like a company is an entity. Since it's a revocable and it's formed during your life, it, you don't obtain any tax benefits. So your personal tax situation is going to apply. If you have an irrevocable trust, there are tax rules regarding what the percentages are for trusts when they have income or they have capital gains, and those rules are going to apply to irrevocable trusts.
Okay. Adam, as far as your reducing tax liability question, it is a little vague. And so what I would say is if you have specific questions regarding that, again, set up a time with us. We'd be happy to go through your specific situation and see if there's some tax reduction that we can do or some tax planning that we can do or help you with. To figure out what taxes you're referring to as far as you're wanting to reduce.
My presumption here is it's a state tax liability. Uh, so there's a couple tools you can, like at the most basic level, there's life insurance trusts. And really all those are doing is if there is an estate tax obligation that needs to be paid, the life insurance trust is there to pay that obligation. That's kind of your, you know, basic entry level tools. And then there's more complex things like charitable trusts, intentionally defective trusts. So it's going to depend on the things you have and what your tax bases are in those assets.
Okay. We have one child, everything will be left to her. Does this change anything in the idea of how things should be laid out in our estate planning? Because there's only one person that everything will be left to?
Uh, no, it just kind of goes back to the conversation of having a will for predictability. If it's the only daughter that either of you have, in Texas, the law is going to say that she's going to ultimately inherit. But again, you're paying for the lawyer to go through the probate process, then you're paying the court appointed lawyer if you don't have a will. So it doesn't change anything, but you just want to do things that cause predictability for your daughter so that she doesn't have, it should be easy for her. It should not be hard for her. So you want to do the things that make things easier for that child in the future.
All right. Let's see here. If I go through probate, will I be required to pay unpaid medical bills from 2015? My husband died in 2015. I no longer live in Texas. The probate would be filed in Texas.
That's a more nuanced question. Because like we talked about in the beginning, probate is a broad term that encompasses a variety of different motions and procedures. Depending upon the type of assets that you have that are still in your husband's name, we probably would need to have a conversation on what the best path forward would be for you in order to get those assets solely in your name.
Nancy, I hope that was helpful. If you want a more specific answer to your situation, again, let's take that question offline and see if we can get it answered for you. Just set up a time that we can talk with you and go through it. Let's see here. Is Don part of your company? Don owns, again, Henderson Law Group. He is a consultant within our company that works with our clients in helping them figure out what exactly they need as far as paperwork, trust, wills, all of that. If you decide to work with him or work with another estate planning attorney, that's completely up to you. But for the clients at Assurance Wealth Management, he is a consultant to help with some of these questions. Let's see here. If your property passes to someone who lives in another state, which state's probate laws would apply?
Yeah. So it's going to apply. So in Texas, the rules are the probate occurs where your primary residence is or where most of your assets are. So if you live and pass away in Montgomery, Harris, or one of the big cities, that's where the probate's going to be, and the Texas laws are going to apply. So the fact that someone lives in, a beneficiary lives in Florida or they live in New York, it's not going to matter because the rules regarding the person who passed away are going to be Texas rules if they pass away in Texas and they lived in Texas.
So let's take that one step further. If I live in Texas, I have property in Colorado,
Mhm,
and my beneficiary is in California,
mhm.
what rules are going to apply in that situation?
Yeah, so presuming your property is controlled by your will, the likelihood is you're gonna have to do a probate in Texas, and then you're probably gonna have to do what's called an ancillary probate in Colorado. Um, with regards to real property, local state laws are going to govern real property, so you usually have to do what's called an ancillary probate, to where you've already probated the will one time in Texas. You have to take that again to the state where the real property exists and do a stripped down probate procedure so that real property in that other state can pass to your beneficiary in California. So having a trust or having some type of transfer on death deed for out of state real property for where you live can go a long way to cut down on your probate costs with just a little bit of planning.
Next question was, can Don prepare some documents outside the state of Texas? Don cannot prepare the documents for you. He can definitely have a conversation with you and give you some generalities as far as what you may or may not need. But as far as legally preparing documents, Don, unless I'm way off here, I'm pretty sure you're only licensed in Texas, right?
Yeah. So if you live in New York, I can't do a will for you. I'm not licensed there. I can form companies in other states, but as far as preparing estate planning documents, if you live in Florida full time, that's not something I'm going to be able to do because I'm only licensed in Texas.
Joey said, thank you for doing this. Very good information. Thank you, Joey, for coming. Thank you everybody for coming. Actually, looks like we've gone through all the questions. Feel free to continue asking these questions. We'll be here for another 10 minutes or so. I also want to let everybody know that we're going to start doing these every month. You will be getting the email invitations every month. We will have a different topic and a different speaker every month. Rachel, who joined us today and had a number of her clients here on this call, Rachel will actually be talking with us next month about taxes. She is a CPA, so obviously it's fitting that she talks about taxes, but we will go through a lot of that next month. We will get the invites out as soon as we nail down a date and time for that. But I want to thank everybody for coming. Again, we will stay here for about 7 or 8 more minutes, answering any questions that anybody has. Thank you again for coming. If you have more specific questions, again, when you exit the webinar, you will be brought to a page where you can schedule a time to talk with us, and just make sure in the notes that you put who it is that you're looking to speak with and what kind of questions that you're looking to get answered. We will be happy to sit down and go through that with you, whether it's live or virtual. And we'll also be sending out an email after this is done to let everybody know, with a link to that if you would like to schedule a time to talk. Let's see here, going through this. Great information, easy to understand. Thank you both for your expertise and time. No problem at all. Again, we're here to help. We're here to educate as much as we can. Thank you. Thanks, guys. Thanks everybody. Thank you guys for coming. If you have any more questions, again, we'll sit down, or we'll be here for a couple more minutes. Doris, yes, because you are a client of ours, he will sit down and have a consultation with you. He's not going to charge you his normal hourly fee. I buy him a lot of lunches so that he doesn't have to do that.
Or if anybody doesn't think their question got answered, maybe they could do the raise their hand button and we can go back to where they initially typed in their question.
Absolutely. Absolutely.
Virginia Jones.
So let's see here, Virginia.
How do you pick an attorney? I
Oh,
believe is the question.
yep.
Yeah,
Missed
so
one.
for estate planning and probate attorneys, my recommendation is that you choose an attorney who does that on a regular basis. The problem with estate planning and probate attorneys is sometimes that people offer those services because everybody needs those services, and they really don't have the skill and the expertise in those fields. They're really, the attorney's really just trying to make a living. there's a misconception that, you know, lawyers are all buku rich, but the fact of the matter is, especially in Texas, that lawyers are a dime a dozen, and you want to make sure that the person has good experience in their particular estate planning and probate field that'll get you taken care of. Um, you know, a website that's, you know, looks legitimate is always, you know, passing the smell test is always a good first thing to look at.
The old digital business card these days. I've
Yes.
had this question asked a couple times here. Typical estate planning costs, had a run-of-the-mill estate plan with basic 5 documents. What do you estimate the cost should be? And I think this is going to vary attorney to attorney, state to state even. So, Donnie, do you have an idea of a range?
Yeah, I can tell you, I try to do, if at all possible, my estate planning on a flat fee basis so that you have predictability that the cost is not going to spiral out of control. For what I would call a very simple estate, you know, husband and wife, you're going to be in the $2,000 to $3,000 range more than likely, depending upon what exactly are the documents that we're going to prepare.
And that may be a good idea for people, again, kind of going back to Virginia's question about how do you find the attorney. I think we've all seen the horror stories, or maybe some of you have dealt with them when it comes to attorneys and paying them on an hourly rate, not knowing what you're going to get. And,
Yeah.
you know, they may tell you you're going to pay an hourly rate of $400 or $500,
Mhm.
and, you know, it ends up taking them 10 hours to complete your will, which it shouldn't. But, you know, they may charge you for 10 hours on doing this, and then you're in for a lot more than you thought you were originally supposed to be in for, which I think is why Don
Yeah.
typically does everything on a flat fee that's determined up
Yeah.
front.
Yeah, I don't do all my work on flat fees, but I understand that people like predictability, and if at all possible, I will do estate planning on a flat fee. But there are situations that arise where you can't help it. You get into a bag of worms and you're stuck doing hourly, and it's going to take as long as it's going to take. Uh,
Don, is there a difference we had here? A question about, is there a difference between an elder attorney to protect assets versus
uh,
an estate planning attorney?
Kind of. Usually, when I see people utilizing the phrase that they're an elder attorney, it's usually used in some type of Medicaid, not Medicare, Medicaid situation. Medicaid is very specific in their requirements on what assets you're allowed to have. And there are some attorneys that they're only Medicaid planning attorneys. So if you have the expectation that one of, you know, your spouse or yourself is going to have some type of debilitating medical condition in the future where you might run out of funds to pay for, you know, assisted living or whatnot, uh, it may be beneficial to have a conversation with a Medicaid specific planning attorney. I can advise generally on the basics of Medicaid and what assets are included and what assets are excluded. So if you do think you have a real need, I would encourage you to, you know, at the very minimum, schedule a meeting with Jaimin, and then he can direct you to the right person to have that additional conversation.
Perfect. Well, that looks like it, and it looks like we're running right up against our time here of an hour. Want to respect everybody's time. If you took some time off of out of your day to come here and join us on this, so I want to respect that. If anybody has any further questions, or you think of something, you know, one of those things, as soon as you walk out the door, you think of 5 more questions, feel free to email myself, or schedule a time to come and talk to us. You can find my email at our website there, assurancewealthmanagement.com, or we will also be sending out an email after this to let everybody know, you know, how to schedule a call, or how to ask some more questions. Or also, I believe that we also have a recording of this that we're going to be sending out to all of you guys. I don't know that it's going to be available permanently. I'm not sure how that works. That's up to Rebecca on the tech side. So, but we will be sending out a recording of this to anybody who attended today so that you can kind of go back and look at anything that you missed. But again, appreciate everybody for coming out. Don, thank you for taking your time and talking with everybody today.
Thank you for having me.
And we'll like I said, we're going to be having another one of these next month, more geared towards taxes with a CPA, very smart CPA and tax planner, not just a tax preparer, but a tax planner. Her name is Rachel. She'll be joining us next month and going through a very similar webinar. Thank you guys for coming. If you have anything else, please let us know.
Thank you.